case briefs, and so much more. LSData's got what you're looking for.
In the 1967 case of Silas v. Bowen, a basketball player and his friend brought a controversial lawsuit against a parking lot operator. The case was heard in the United States District Court for the District of South Carolina and centered on the principle that property owners can use force to remove trespassers, but not deadly force, unless they have a reasonable fear of serious bodily harm. The conflict began when the St. Louis Hawks basketball player, a Missouri resident, brought his car to the defendant's parking lot outside Fort Jackson for repairs. After becoming intoxicated and dissatisfied with the repairs, the plaintiff and his friend returned to the parking lot to demand a correction. Witnesses described the basketball player as drunk, aggressive, and refusing to leave the premises. In response, the parking lot operator, who was armed with a shotgun, claimed that he shot the plaintiff in self-defense. During the trial, it was discovered that the basketball player arrived at the military base later than he had originally claimed. The court ultimately decided that the defendant's use of force was a reasonable act of self-defense, as the basketball player's conduct created a legitimate fear of serious bodily harm. As a result, the court ruled in favor of the parking lot operator, and the plaintiff's claim was barred by the successful self-defense plea.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.